So in New Jersey, there's three ways about getting a temporary protective order. The first is going to any police station and describing any incidents of domestic violence or harassment that have occurred. The police officer will then take a report and contact an emergent family court judge. That temporary restraining order can be issued the same day. Again, it's a temporary restraining order, meaning you'll have to eventually go to court, and that usually is scheduled around the 10-day mark. A judge will then determine whether a predicate act of domestic violence occurred and whether your safety and physical integrity are at risk if a final restraining order is not granted. The alternate way of doing that is to go directly to a family court yourself, and they'll always have a domestic violence resource center, and you can apply for one directly with the court. Again, a hearing will be scheduled roughly within 10 to 12 days, and you'll be able to, again, present your case before a judge as to why you need a final restraining order. Alternatively, you can contact an attorney. An attorney can go and help you at the court fill one out on your behalf. Attorneys are often best suited to assist with those matters because we're well versed in what can be used in court against the aggressor. An attorney will likely include far more information than you would think to include yourself, including past incidents of domestic violence. And those can be important because if they're not described in your initial filing, you will not be able to use those events against the aggressor in court. And you won't have that information for the judge to analyze, which could hinder his ability to grant you a final restraining order. Judges must look and often look at the entire relationship as a whole. Perhaps the last incident wasn't so severe, but several incidents in the past were super severe, and that could be the differentiating factor between you being granted a permanent protective order versus not granting that order. So in New Jersey, you can include your children as a protected party. And this is especially important when your former partner has threatened or harmed the children in addition to you. Or if your former partner was aggressive and abusive to you in front of your children. Judges take that very seriously. Witnessing abuse can often have significant effects on a child's emotional and psychological development. And typically, in a temporary restraining order, a judge will automatically award custody, especially if those children are mentioned in the temporary restraining order as a necessary protected party. This can help you if your children or yourself are facing immediate harm and need to temporarily move to a different location for your safety. If you are granted sole physical custody as part of a temporary restraining order, your former partner cannot use you moving the child against you, and you can discuss further custody arrangements at the hearing for the final restraining order. Judges that hear those cases do have jurisdiction and authority to make decisions regarding child custody, and often do as part of these proceedings. In order to document abuse, which is often highly critical in proceedings involving temporary restraining orders and your request for a final protective order, many different bits of evidence can be used to help you prove your case. You'll be asked to authenticate this evidence in court, but generally, anything such as text communications between the parties, and it's critically important that dates are displayed of these messages because they can often establish the timeline of abuse that's highly necessary for a judge to evaluate. Videos of abuse, any audio recordings, ring camera footage, as well as you can bring witnesses on the day of trial that have witnessed the abuse, and they can testify under penalty of perjury what they witnessed. Any hospital records, any police records, any previous restraining orders that you filed can be also introduced in court. It's necessary to the best of your ability to document certain things as they happen. A judge might look disfavorably in terms of your credibility if you wait too long to file a restraining order after these domestic abuse incidents occur. However, Even if you don't get a temporary restraining order because of that one particular incident in the past, if you have documentary evidence that they happened, a court can often look to that as a point of analysis when evaluating whether or not you need a final restraining order. A lot of the times people think that they can pretty much introduce any and all evidence and witnesses in court. However, family courts follow strict courtroom rules that are established by the statute. Essentially, not everything that someone hears can be used in a courtroom. For example, an objection that the other side might often say is if one of your witnesses says that you told them something, which is hearsay, which is an out-of-court statement meant to prove the truth of the matter asserted. That's an objection that the other side will often use. So essentially, witnesses, for example, should really only be called to testify about anything that they observed directly. They can testify that they saw you with bruising. They can testify that they witnessed abusive behavior. But those statements also need to be included generally in a request for a temporary restraining order, which is why it's so necessary to be fully candid with your attorney and make sure that the attorney knows all of the major past incidents so they can be as descriptive as possible in their initial complaint. That complaint might be a limiting factor in terms of what can be then discussed in trial or introduced in trial. Again, all documentary evidence must be what's called authenticated in a courtroom to be used against the other party, meaning it's necessary to have time and dates and text messages available. I often tell my clients to change the contact name just to display that person's number so the judge can see those text messages actually came from that number. Any photographic evidence typically is more persuasive to a judge if it's printed in color, and I always make sure to tell my clients to bring 3 copies, which is one that's needed for the judge, one that's needed for the other side, and one that's can be used by your attorney. If you're representing yourself, the judge still requires you to follow the court rules and will have the same expectations as if you were represented. If you have any questions about how to obtain a restraining order in the state of New Jersey, please contact us at Next Chapter Family Law. We're here and we're happy to help you.